Your Excellency, you have the floor.
Mr. President, distinguished members of the Court, it is a great honor and privilege to appear before you on behalf of China. China is committed to promoting the rule of law in international relations, stands in firm support of the Court in preserving and safeguarding international peace and security, international order, fairness, and justice. Dealing with the question of Palestinians served as a litmus test for collective conscience of humanity, the wisdom of United Nations, and the authority of international law. The question of Palestinians has persisted for over a half a century, inflicting sufferings across generations. Countless Palestinians have been waiting in vain their entire lives. Yet, there remains no glimmer of hope in their efforts to restore the legitimate rights of Palestinian people. Fundamentally, the foundation of two-state solution has been continually eroding. The relevant UN resolutions have not been effectively implemented. China has consistently supported the just cause of the Palestinian people in restoring their legitimate right. Chinese President Xi Jinping has stressed on multiple occasions that China calls for comprehensive ceasefire and early solution to the question of Palestine on the basis of two-state solution through negotiation. China submitted its written statement to the Court last July. Today, I would like to further elaborate on China's view. My statement will be three parts, dealing with respectively the advisory jurisdiction of the Court, self-determination of peoples, as well as jus ad bellum and international humanitarian law. Mr. President, I will now turn to address the matter of jurisdiction. In this regard, China submits that the Court has jurisdiction over this case, and there is no compelling reason for the Court to decline to exercise its jurisdiction. China observes that some written statements submitted last July claim that there are compelling reasons for the Court to decline to render advisory opinion. Their main concerns are, first, an advisory opinion would circumvent the principle of consent. Second, the advisory opinion would undermine the established legal framework for resolving the question of Palestine of adversely impact negotiation process. China is of the view that these two arguments are not tenable. First, the subject of present request falls within competence of the General Assembly and has always been on its agenda. Therefore, the Court, by rendering advisory opinion in this case, would not circumvent the principle of consent in the settlement of bilateral dispute. The question of Palestine, with origin in this mandate system on the League of Nations, go beyond the scope of bilateral affairs between Palestine and Israel. It directly relates to the responsibility of the UN on international peace and security. The UN has permanent responsibility toward the question of Palestine. Second, the issuance of advisory opinion by the court would not contradict the established legal framework or disrupt negotiations to settle the question of Palestine in accordance with international law. The court's advisory opinion will not set up new legal framework or rules. Rather, it will find its basis in the established legal framework, including relevant Security Council resolutions and Oslo Accords, and present an interpretation of relevant legal questions. Furthermore, the advisory opinion will offer clearer legal guidance on the legal issues involved in the negotiations, thus facilitating the relaunching the negotiation process. China supports the court in discharging its jurisdiction in accordance with the law, with focus on identifying, interpreting, and applying existing rules, upholding the purposes and principles of the UN Charter, providing legal guidance to UN in dealing with the question of Palestine, and fostering proper settlement through peace talk. Mr. President, now I will turn to the Palestinian people's right to self-determination. The Palestinian-Israeli conflict stems from Israel's prolonged occupation of Palestinian territory and Israel's long-standing oppression of the Palestinian people. The Palestinian people fight against Israeli oppression and their struggle for completing establishment of an independent state on the occupied territory are essentially just actions for restoring their legitimate rights. The right to self-determination served as precise legal foundation for their struggle. Self-determination of peoples is a fundamental principle of modern international law, enshrined in the UN Charter and collective human right under customary international law. In 1955, during the Bandung Conference, the Chinese Premier and Foreign Minister Zhou Enlai solemnly declared, I quote, "full support of the principle of self-determination of the peoples and the nations, as set forth in the UN Charter, and took note of the UN resolution on the rights of peoples and the nations to self-determination, which is a prerequisite of full enjoyment of all fundamental human rights." End of quote. This declaration was fully incorporated into the final communique of Bandung Conference. Let me clarify that self-determination only applies to two scenarios, namely peoples under colonial domination or foreign occupation. Under no circumstances does the right to self-determination offer any basis for any part or group within the sovereign state to claim a so-called right to secession. International law does not recognize the existence of right to so-called remedial secession or remedial self-determination. The Palestinian people, being a group residing in territory under foreign domination, is a sui generis in international legal person as a whole. The right to self-determination of Palestinian people has been consistently reaffirmed in multiple UN resolutions and the War Advisory Opinion. This is also widely recognized by most states and international organizations. The Palestinian people enjoy the right to self-determination, which includes 5 main aspects. First, the right to preserve territorial integrity. Second, the right to maintain national unity. That is, Palestinian people in its group identity collectively enjoys and exercises the right to self-determination. Third, the right to freely determine their political status. Fourth, the right to freely pursue economic, social, cultural development. And fifth, the right to permanent sovereignty over natural wealth and resources. Every state is obliged to promote the realization of the right to self-determination and to refrain from any forcible action which deprives peoples of that right. In pursuit of the right to self-determination, these people have the right to engage in struggles, seek and receive support. On the basis of that right, Palestinian people declared the establishment of State Palestine in 1988, which has been recognized by over 130 countries. In pursuit of the right to self-determination, Palestinian people use force to resist foreign oppression and complete the establishment of an independent state. Is inalienable right, well founded in international law. Various people freed themselves from colonial rule and foreign oppression to realize independent statehood after World War II. Their practices serve as convincing evidence for the right. Numerous AGA resolutions recognize legitimacy of struggling by all available means, including armed struggle by peoples under colonial domination or foreign occupation, to realize the right to self-determination. For instance, the UNGA Resolution 3070 of 1973, I quote, reaffirms the legitimacy of the people's struggle for liberation from colonial and foreign domination and alien subjugation by all available means, including armed struggle, end of quote. This recognition is also reflected in international conventions. For example, the Arab Convention for Suppressing of Terrorism of 1998 affirms, I quote, the right of peoples to combat foreign occupation, aggression by whatever means, including armed struggle, in order to liberate their territories and secure the right to self-determination and independence, end of quote. Armed struggle in this context is distinguished from acts of terrorism. It is grounded in the international law. This distinction is acknowledged by several international conventions. For example, Article 3 of the OAU Convention on the Prevention and Combating the Terrorism of 1999 provides that, I quote, the struggle waged by peoples in accordance with the principle of international law for their liberation of self-determination, including armed struggle, against colonialism, occupation, aggression, and domination by foreign forces, shall not be considered as terrorist acts. It should be emphasized that the use of force by any entity or individual in the name of exercising the right to self-determination outside the context of colonial domination or foreign occupation is not legitimate. Meanwhile, during legitimate armed struggle by peoples, all parties are obliged to comply with IHL, and in particular, refrain from committing acts of terrorism in violation of IHL. Against the backdrop of the OPT, well-documented and widely recognized facts indicate that Israel's oppression policies and practices throughout its prolonged occupation of Palestinian territory have severely undermined and impeded the exercise and full realization of the Palestinian people's right to self-determination. Mr. President, now I will move on to the issue of international law relating to the occupation. In China's view, the question of OPT involved both legality of occupation per se and the legality of Israel's act during the occupation. These two aspects are governed by distinct legal frameworks. The former falls under jus ad bellum, while the latter is mainly regulated by IHL. Within the framework of jus ad bellum, the principle and exceptions are established by the UN Charter and customary international law. The principle of non-use of force is at the core of jus ad bellum. As corollary of this principle, the prohibition on acquisition of territory by force is firmly established in customary international law. Using force to occupy and maintain such occupation for the purposes of territory acquisition or annexing an occupied territory by force in whole or in part is each illegal. They are confirmed by the Friendly Relations Declaration of 1970, the definition of aggression of 1974, and the War Advisory Opinion. Israel's occupation has been explicitly recognized as unlawful by several UN resolutions. Following Israel's occupation of the Palestinian territories in 1967, of the Security Council adopted resolutions 242 that, I quote, emphasizes the inadmissibility of the acquisition of territory by war. Similarly, multiple UNGA resolutions affirmed the illegality of Israel's occupation. In addition to the use of force by peoples under colonial domination or foreign occupation in the exercise of their right to self-determination, the UN Charter provides for two exceptions to the principle of non-use of force, namely, the use of force authorized by the Security Council under Chapter 7 and the right of self-defense under Article 51. The exercise of the right to self-defense as an inherent right of states is contingent upon the occurrence of the armed attack against territorial sovereignty of a state. When can an occupying power invoke the right of self-defense? It hinges on whether the armed attack occurs in the occupied territory or within its own territory. In the occupied territory, the right of occupying power to self-defense depends on the legitimacy of the occupation per se. If occupation is unlawful, the occupying power can neither acquire territorial sovereignty nor resort to self-defense against armed attack that occurred in the occupied territory. This is rooted in the legal maxim, I quote, "No one can take advantage of his own wrong," end of quote. However, this does not rule out the possibility for the occupied power, based on temporary administration as a last resort, to take necessary forcible law enforcement measures against individuals or entity in the occupied territory. Nor does it preclude the use of force by occupying power against the combatants and military targets in accordance with jus in bello. These acts must stay within the limits set by international law. Within their own territory, an occupying power is entitled to self-defense against an armed attack. However, the exercise of this right is subject to various principles, including necessity and proportionality, as reflected in customary international law. Under the framework of ICJ, the legality of not of the occupying per se will not affect the application of ICJ in the occupied territory. The armed conflict in which oppressed peoples struggle against colonial domination or foreign occupation in the exercise of the right to self-determination is considered as international armed conflict. Consequently, ICJ, including the rules of belligerent occupation, is applicable to all parties involved in such conflict. It is noted that belligerent occupation is a special regime involving the temporary administration of occupied territory by occupying power, and it is governed by two principles. First, the principle of temporary administration, that is, the occupying power can exercise provisional jurisdiction over occupied territory, include limited but necessary legislative, judicial, and law enforcement power, with the obligation to maintain law and order and public life in good faith. Meanwhile, the occupying power is obliged to respect and protect civilians and property in the occupied territory under ICJ and international human rights law. It should serve the best interest of the people of the occupied territories and refrain from plundering resources and property, forcible transferring or deporting inhabitants, practicing apartheid, adopting discriminatory legislation, and other related violations. Second, the principle of non-alteration of the territorial sovereignty of the occupied territory. This is corollary of principle of prohibition on the acquisition of territory by force. It underscores the non-sovereign nature of belligerent occupation. The occupation power is obliged to preserve status quo ante of the occupied territory and refrain from altering sovereignty over the occupied territory. Obviously, the rules of belligerent occupation are applicable to the OPT and should be followed by both parties to the conflict. Facts indicate that relevant Israeli policies and practices have violated IHL and international human rights law. China is of the view that temporary and non-sovereign nature of belligerent occupation means that an occupying power cannot acquire sovereignty over the territory during the belligerency. Belligerent occupation, under any circumstances, does not have the effect of the lawful annexation. The rules of acquisitive prescription in international law does not apply to belligerent occupation. 57 years have passed since Israel began its occupation of the OPT. Regardless of the duration of the occupation, the unlawful nature of the occupation and the sovereignty over the occupied territories remain unchanged. Mr. President, justice has been long delayed, but it must not be denied. The settlement of the question of Palestine requires mutual efforts from Palestine and Israel, along with the joint efforts of the international community. China encourages both parties to accommodate each other's legitimate concerns, embrace the vision of common, comprehensive, cooperative, and sustainable security, continue negotiating for peaceful settlement, and work toward two states coexisting in peace, and two peoples living side by side in harmony. Mr. President, distinguished members of the court, that concludes China's statement. I would like to thank you for your patient attention. I also wish to thank the registry and all the staff for your kind support. Thank you all.
I thank the delegation of China for its presentation. I invite the next participating delegation, the Islamic Republic of Iran, to address the court. I call upon His Excellency Raza Najafi to take the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, distinguished members of the court, it is indeed an honor to appear before the International Court of Justice on behalf of the Islamic Republic of Iran. Enjoying a long-standing principled position in support of the full realization of the inherent right of the Palestinian people to self-determination, the Islamic Republic of Iran follows these advisory proceedings of the court with great interest. What makes this proceeding even more prominent and focused of attention of almost every nation in the world is its concurrence with the ongoing appalling situation in Palestine, particularly the Gaza Strip. To indicate how severe and grave the situation in Gaza is, I merely refer to 3 United Nations and World Health Organization reports. First, according to the UN Secretary General, as a result of Israeli military operation, the entire population is enduring destruction at a scale and speed without parallel in recent history, and 2.2 million Palestinians, they're struggling to simply make it through another day without proper shelter, heating, sanitary facilities, food, and drinking water. Second, according to the UN Under-Secretary General for Humanitarian Affairs, and I quote, "For children in particular, there is no food, no water, no school, nothing but the terrifying sounds of war, day in and day out, and its people are witnessing daily threat to their very existence while the world watches on, end of quote. Third, according to the WHO, the population in Gaza is facing extreme hunger with insufficient food and high level of malnutrition. Yet, the conditions in Gaza are becoming much worse every day. We remain at a turning point in the history of mankind. The opinion of this court can set the ground for saving lives of thousands of innocent women and children and contribute to the legitimate demand of the people deprived of its inherent right to self-determination for decades. It is hoped that this court will once more make history by giving a landmark advisory opinion in support of the right to self-determination of Palestinian people, which may finally help seize the illegal, prolonged occupation of Palestine. Mr. President, members of the court, in oral statement, we submit that, firstly, this court has jurisdiction to give advisory opinion requested. Secondly, there are legal consequences arising from the prolonged occupation of Palestinian territories by Israeli occupying regime in violation of the right of Palestinian people who have never experienced the right to self-determination. And thirdly, having elaborated on the legal consequences that arise for all states and the United Nations from this status, I will reiterate the inclusive plan previously submitted by the Islamic Republic of Iran to the United Nations for realization of the right of Palestinians to self-determination. Mr. President, first we submit that the court has jurisdiction to render the advisory opinion requested by the General Assembly in Resolution 77/247 of 30 December 2022. Here we believe that the elements of Article 65(1) of the statute of the court, namely the existence of the legal question and the authorized body, it means General Assembly, are fulfilled in this case. That said, the ICJ, as the principal judicial organ of the United Nations, can assist the General Assembly to exercise its functions under the UN Charter by rendering the advisory opinion requested. Therefore, just as the court has established its jurisdiction in the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territory, it has jurisdiction in the present case based on the same grounds. Moreover, there is no compelling reason for declining to give an advisory opinion. Mr. President, now I turn to the first section of our reasoning regarding the merits of the matter. Here we first argue that the Israeli occupying regime has violated and continues to violate on several grounds the Palestinians' right to self-determination. The legal status of the right to self-determination is generally understood to be attributed to peoples and grounded first in the UN Charter, in several UN General Assembly resolutions, and its inclusion in Common Article 1 of the two International Covenants of Human Rights. As such, and I quote, all peoples have the right freely to determine without external interference their political status and their place in the international community, and to pursue their economic, social, and cultural development, and every state has the duty to respect this right in accordance with the provisions of the Charter. End of quote. In line with the elements mentioned in the question raised for the request of the advisory opinion in the General Assembly resolution, I briefly present my arguments on a series of measures that constitute the ongoing violation by Israeli occupying regime. These are as follows: 1, prolonged occupation; 2, altering demographic composition in the occupied territories; 3, altering the character and status of the holy city of Al-Quds; 4, discriminatory measures; and 5, violation of the right of Palestinian people to permanent sovereignty over their natural resources. First and foremost, the prolonged occupation by Israeli occupying regime confirms its intention to make it permanent, in violation of the principle of prohibition of acquisition of the territory by force. The occupation of Palestinian territories is the longest military occupation existing today. The right to self-determination of Palestinian people continues to be violated as long as this occupation ages. This ongoing violation towards Palestinians' ability to rely on state-based rights and obligations under international law, depriving them of their inalienable right to self-determination, including the right to live in freedom, justice, and dignity. Thus, we request the Court to consider the very fact of prolongation of the occupation as an indicator of the violation of the right of Palestinians to self-determination. Mr. President, apart from prolonged occupation altering the demographic composition in the occupied territories has led to violation of Palestinians' right to self-determination. The UN Security Council has a bulk of resolution concerning the occupation of Palestinian territories, all condemning, among others, altering the demographic composition of these territories by the Israeli occupying power. Hence, it is a well-established fact that the Israeli occupying regime has grossly violated international law on an ongoing basis. Article 49 of the Fourth Geneva Convention reads, and I quote, "The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies," end of quote. Apart from that, the Court, in its opinion in the Wall case, declared that, and I quote, "The provisions prohibit not only deportation or forced transfers of population, such as those carried out during the Second World War, but also any measures taken by an occupying power in order to organize or encourage transfers of parts of its own population in the occupied territory," end of quote. Furthermore, the Court affirmed in the same case the violation of the right to self-determination based on measures taken by occupying power, which has led to a change in the demographic composition of Palestine. Mr. President, members of the Court, forcible deportation of civilian populations, widely known for one of its most infamous stances as Nakba Day, has a long history. Essentially, with the illegal formation of Israeli occupying regime in 1948 instead of former British Mandate of Palestine, the demographic composition changed significantly with the displacement of more than 700,000 Palestinians. In fact, the Israeli occupying regime was illegally established that year through a violent, arbitrary process and involved the deportation or forcible transfer of hundreds of thousands of native Palestinians from their land to create a majority Jewish colony in line with the demand of the Zionist movement. By denying the right to return of forcibly deported Palestinians to Palestine, the Israeli regime continues to deprive those Palestinians of their right to live in their homeland. The majority of Palestinians live outside Palestine, namely in Jordan, Syria, and Lebanon, with many of them remaining stateless, living in crowded refugee camps that lack basic infrastructure. Needless to say, forcible displacement of civilian population is of such a high significance that has been defined as a war crime under Article 8 of the Statute of the International Criminal Court. Mr. President, the next measure that has violated the right of self-determination of Palestinians is altering the character and status of the holy city of Al-Quds. The action taken by the Israeli occupying regime with regard to the holy city of Al-Quds have utterly disregarded the right to self-determination of the Palestinian people. Altering the character and status of Al-Quds has had significant religious and cultural implications for Palestinian people. Al-Quds al-Sharif has a remarkable religious and historical significance for Palestinians, as well as Muslims, Christians, and Jews worldwide. By altering the status quo of the city and its holy site, the Israeli occupying regime has undermined the cultural heritage and identity of the Palestinian people and has further violated their right to self-determination. The construction and expansion of the settlements, along with the violation of Palestinians' right to free movement and revocation of residency permits, have altered the demographic and cultural character of the city as well. Mr. President, members of the Court, the next series of measures depriving the Palestinian people of their right to self-determination comprise of discriminatory measures targeting the basic rights of the people in the occupied territories. This has been underlined by the UN General Assembly and recorded extensively to include the killing and injury of civilians, the forced displacement of civilians, and a systematic policy of obstruction of humanitarian assistance. The Israeli occupying action, as manifested in various laws and policies, have created a system of discrimination that has negatively affected the Palestinian population. In Palestine, the occupying regime's expansionism has consolidated into apartheid through the longest occupation in modern history. It is well established that apartheid is a crime against conscience and dignity of mankind, and is further in violation of fundamental principles of international law enshrined in the UN Charter and crystallized in the international human rights law, and seriously threatens international peace and security. The Special Rapporteur on the situation of human rights in Palestine has concluded that the political system of entrenched rule in occupied Palestine, which endows one racial, national, ethnic group with substantial rights, benefits, and privileges, while intentionally subjecting another group to leave behind walls and checkpoints under a permanent military rule, satisfies the prevailing evidentiary standard for existence of apartheid. Many laws, policies, and practices and implemented since 1948 by Israeli occupying regime have been aimed at fragmenting the Palestinian people and dividing them into various groups. This clearly denies the Palestinian people its right to self-determination. In tandem with the above, construction and expansion of the settlements, segregated roads, barriers, and checkpoints has created a system of apartheid, effectively isolating Palestinian communities, which manifestly violates multiple provisions of the Convention on the Elimination of All Forms of Racial Discrimination. The Court is therefore requested to opine that such policies and practices must be ceased immediately as they continue to violate the right of self-determination of Palestinian people. Mr. President, members of the Court, the right to exercise permanent sovereignty over natural resources is an inevitable component of the right to self-determination. The two international covenants of human rights and a number of UN General Assembly resolutions recognize this right. The UN General Assembly has expressed grave concern over a range of practices by Israeli occupying regime, negatively impacting Palestinians' natural resources. It has been affirmed the right of Palestinian people to permanent sovereignty over their national wealth and resources as an integral component of the right to self-determination. It has been further confirmed that the right should be used in the interest of their national development. the well-being of the Palestinian people, and as part of their right to self-determination. Yet Palestinians do not enjoy their own natural resources, which include land, fresh water, and mineral resources. Imposing restrictions by the Israeli regime on access of Palestinians to water resources, groundwater, and hydrocarbon deposits are all instances of flagrant violation of the right to self-determination. Mr. President, members of the court, this court has in several cases, in particular in Wall case, identified the obligation to respect the right of self-determination have an erga omnes character as one of the essential principles of contemporary international law. As a general rule, where erga omnes obligations of international law are breached, third states have mainly three obligations. Firstly, non-assistance, secondly, non-recognition, and lastly, cooperation to bring to an end such violation. In this context, an interested or third state, in accordance with the jurisprudence of the ICJ, could be defined as one which is not directly affected or injured by an internationally wrongful act, and which has yet a legal interest in the protection and compliance of the rights by the very reason of importance of the rights involved, and this very nature makes them the concern of all states. As regards the primary obligations of the third state toward prolonged occupation of Palestine, the three obligations mentioned above remained relevant in accordance with the paragraph 146 of the 2004 ICJ advisory opinion in the Wall case. In addition to the jurisprudence of ICJ, the primary triple obligations of third states towards serious breaches of erga omnes obligations find support in the practice of other United Nations organs as well. In its resolution 2334, the UN Security Council unequivocally reiterated the importance of states abstaining from recognizing occupying powers' internationally wrongful acts. The International Law Commission's in draft Article 41.1 of its 2001 draft articles on responsibility of a state for internationally wrongful acts, along with underlying the duty of a state to not recognize as lawful a situation created by a serious breach of erga omnes rules, and not to render the aid or assistance in maintaining that situation, emphasized the duty of all states to cooperate through lawful means in a joint and coordinated effort to counteract the effects of these breaches. Mr. President, in light of above mentioned, the Court is requested to remind all states of their obligations under international law of the following. First, not to aid or assist directly or indirectly the Israeli occupying regime, enabling it to continue its prolonged occupation of Palestine and or any of its continued policies and practices that violate the right to self-determination of Palestinian people. This may include, in particular, avoiding any kind of political, military, economic, or other cooperation with the Israeli regime, enabling it to continue such violations. Second, not to recognize the illegal situation resulting from prolonged occupation by the Israeli occupying regime of Palestinian territory and or any of its continued measures that violate the right to self-determination of Palestinian people, and third, to cooperate effectively with one another in all relevant fields and forums to bring to an end any impediment resulting from the ongoing violation by the Israeli occupying regime of the right of the Palestinian people to self-determination, including from its prolonged occupation and any of its measures aimed at altering the demographic composition, character, and status of the holy city of Al-Quds. Obviously, such cooperation is of utmost urgency and importance given the ongoing situation in Gaza Strip. where, according to one estimate, Israel's military is killing Palestinians at an average rate of 250 people a day, which exceeds the daily death toll of any other major conflict of recent years. In this context, I recall this Honorable Court's important order of 26 January 2024 on the request by South Africa for indication of provisional measures. The order concerns application of the Convention on the Prevention and Punishment of the Crime of Genocide, and as such, all states, in particular those providing support to Israel, are legally under the duty to prevent genocide, particularly by ceasing to provide any aid to the genocider. They are under a duty to punish perpetrators of the crime of genocide. Given the current extremely tragic conditions in Gaza Strip, the Court is respectfully requested to once again call on the occupying regime to fully comply with the order. Evidently, in practical terms, even the partial compliance of the Israeli regime with only subparagraph 1 of paragraph 86 of that order is possible only through complete termination of all its military operations in the Gaza Strip. Mr. President, I would like to recall the primary responsibility of the Security Council for the maintenance of international peace and security under Article 24 of the UN Charter. I submit that the inaction or insufficient action of the Security Council, if not the main, is one of the main causes of prolonged occupation of the Palestinian territories. All the atrocities and crimes committed by the Israeli regime in the past almost 80 years are a consequence of such inaction. Even today, the Security Council is paralyzed due to the stalemate caused by a certain permanent member. Other relevant United Nations bodies have also responsibility to monitor and document human rights violations and to facilitate bringing the perpetrators to justice. This fact alone underscores how essential it is for the Court to remind the Security Council of its charter-based obligation. It must also be made clear that such an obligation cannot be fulfilled by convening meetings or issuing certain important procedural resolutions. Rather, it needs conclusive decisions under Chapter 7 of the United Nations Charter and a follow-up mechanism to ensure its full and prompt implementation by the Israeli regime. Mr. President, as our Supreme Leader said, the calamity of Gaza is the calamity of humanity and international community as a whole. Therefore, each and every state and relevant international organization has its own legal and moral responsibility to act urgently and decisively to prevent the ongoing crimes of the Israeli regime in Gaza Strip. Definitely, as the principal judicial organ of the United Nations, this Court has an important role to play. Now the world nations expect the Court to render its advisory opinion in a manner that effectively and practically consolidate the rule of law to the deterrent of the rule of power, and to bring hope to Palestinians that justice will ultimately prevail. We should not leave them alone and let them down in ways that they need the support and assistance of humanity the most. This is a collective legal and moral responsibility, and we must fulfill it responsibly. Finally, Mr. President, I must stress that our participation in this hearing and the content of our statement here is without prejudice to the long-standing position of the Islamic Republic of Iran regarding the question of Palestine. In view of the Islamic Republic of Iran, the only legal, practical, democratic, and just method to effectively realize the inherent right to self-determination of the Palestinian people is to hold a national referendum in Palestine. The details of this plan are contained in an official document of the United Nations issued in 2019. Lastly, This statement shall in no way imply or recognition of Israel. I thank you, Mr. President.
I thank the delegation of the Islamic Republic of Iran for its presentation. I invite the next participating delegation, Iraq, to address the court and call Mr. Haidar Shia al-Barraq to the podium.
Thank you. Mr. President, members of the court, may the peace, mercy and blessings of God be upon you. I extend to you my greetings of peace, mercy and blessing that are said, intended and hoped for by nearly 1 billion people in this world. Mr. President, members of the court, ladies and gentlemen, those who are calling for justice in every corner of the globe. It is an honor for me to represent the Republic of Iraq before the International Court of Justice today and to address your esteemed justice and humanity conscience in the tragedy of a country called Palestine and the ordeal of its people, which began in 1948 and continues to endure. As we gather in this place that captures the attention for being the fortress of international justice at an exceptional time experienced by humanity and the honorable people around the world who seek justice for the oppressed Palestinian people. Who have suffered and continue to endure ongoing injustice for 7 decades. We are confident that the decisions of your distinguished court will remain a beacon of hope and guidance for all the persecuted and oppressed worldwide. Iraq would also like to express gratitude to its friend, the State of South Africa, for presenting the case of unprecedented human rights violations committed by the occupying Israeli entity against the oppressed Palestinian people before your esteemed court. Mr. President, members of the court, we would like to bring to the attention of your distinguished court the decision of the United Nations General Assembly, Resolution 77/247, adopted during its 56th session on December 30, 2022, under Agenda Item 47, pursuant to Article 96 of the United Nations Charter and in accordance with Article 65 of the Statutes of the International Court of Justice. The General Assembly has decided to request an advisory opinion from your esteemed court on the matters referred to in paragraph 18 of the aforementioned resolution. The Republic of Iraq attach utmost importance to the supremacy of international law based on the purposes and principles of the United Nations Charter and international treaties concerning human rights and relevant international instruments, and the role of the International Court of Justice as the principal judicial organ of the United Nations. And based on the aforementioned, Iraq wants to take this opportunity to present its case and express its views regarding the pending request for an advisory opinion. Iraq believes that the court's opinion will provide the necessary legal elements to enhance efforts aimed at restoring peace and stability in Palestine and the Middle East region. Particularly noteworthy is the fact that the Court has on previous occasions considered cases and issued opinions related to practices and violations against the rights of the Palestinian people. And specifically, I refer to the advisory opinion regarding the legal consequences arising from the construction of the wall in the occupied Palestinian territories in 2004. Mr. President, members of the Court, recalling today your distinguished court order dated 26th of January 2024 on the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israeli occupying entity, we are convinced that the Court's orders under Article 41 of the Statute of the Court are of binding effect under Article 94 of the Charter of the United Nations, and we call for the respect of and compliance with these decisions under any circumstance or in any place in order to stop the systematic killing machine against the Palestinian people. We hope that the Court's commitment to justice will lead to additional decisions, affirming its dedication to ending the campaign of mass murder and preventing acts of genocide, as well as policies of harassment, blockade, and starvation against the Palestinian people. Mr. President, members of the Court, Iraq believes that the Court has the jurisdiction to issue the advisory opinion, as a request for the opinion is submitted by the United Nations General Assembly, an authorized body to seek advisory opinions under paragraph 1 of Article 96 of the United Nations Charter. The subject matter of the advisory opinion falls within the competence of the General Assembly of the United Nations. Given that Article 10 of the Charter grants the General Assembly authority regarding any questions or any matters falling within the scope of the Charter. Moreover, paragraph 2 of Article 11 specifically grants the General Assembly jurisdiction concerning any matter relating to the maintenance of international peace and security. The request for the advisory opinion is related to a legal issue, as paragraph 18 of the United Nations General Assembly Resolution 77/247, which has been adopted correctly in procedure terms, signifies. We trust and hope in the justice of the Court, anticipating it to not see compelling reasons for the Court to use its discretion to refrain from issuing an advisory opinion. Mr. President, members of the Court, international human rights law and international humanitarian law apply to the occupied Palestinian territories, and the Israeli occupying entity has the responsibility to fulfill its obligations with regard to the convention to which it has acceded, including the Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant of Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention on the Rights of the Child, the Convention on the Elimination of All Forms of Discrimination against Women, and the Convention on the Rights of Persons with Disabilities. The Israeli occupying entity is also obliged to do so on the basis of the 4 Geneva Conventions. Annual reports of the Secretary General submitted to the Human Rights Council at its 34th session on February 27, 2017, pursuant to Human Rights Council Resolution 31/34 on the human rights situation in the occupied Palestinian territories, emphasizing the continuous and chronic nature of human rights violations leading to these patterns of violations. In this regard, we would like to emphasize that the Israeli occupying entity exercises regional jurisdiction over the occupied Palestinian territories as an occupying entity. Therefore, we call for and emphasize the necessity of compliance with the rules of international law and the decisions issued by your esteemed court. We specifically refer to the advisory opinion issued by your esteemed court regarding the legal consequences of the construction of the wall in the occupied Palestinian territories in the year 2004. Mr. President, members of the court, the Israeli occupying entity commit many violations and breaches of the principles of international law, and the international community has documented these violations, including those substantiated in reports by the Secretary General of the United Nations submitted to the General Assembly or the Human Rights Council. These reports focus on investigating Israeli practices that impact the human rights of the Palestinian people and other Arab inhabitants in the occupied territories, examining the human rights situation in the occupied Palestinian territories. Among these violations perpetrated by the occupying entity against humanity as a whole, and specifically against the Palestinian people, are: 1. The Israeli occupying entity adopts multiple practices that rise to the level of genocide, referring specifically to the Convention of the Prevention and Punishment of the Crime of Genocide of 1948. In particular, under Article 11 of the Convention, which defines acts classified as genocide, the killing practices that have targeted civilians in residential areas, hospitals, schools, and refugee shelters in Palestine in general, and in the Gaza Strip in particular, fall under the provisions of paragraph A, B, and C of that article. Additionally, the 4th Geneva Convention relative to the protection of civilian persons in time of war of 1949, under Articles 146, 147, and 148, stipulates the imposition of criminal sanctions on parties to the Convention in case of non-compliance with its provisions. Two, the oppressive practices affecting the city of Al-Quds, the capital of the Palestinian state, as well as the Holy Al-Aqsa Mosque, as the occupying entity attempts to impose a demographic reality aimed at a subsequent stage, which involves emptying the city of its original inhabitants and settling extremists and racists in it. This constitutes a violation of numerous resolutions, the latest being the United Nations General Assembly decision adopted on December 21st, 2017. This decision came after a series of resolutions emphasizing the necessity of not to prejudice the demographic charter of the holy city of Al-Quds. 3. Imposing a suffocating economic blockade on all industrial, agriculture, and commercial activities is evident in campaigns of land confiscation and seizure of agricultural lands from Palestinian farmers. Additionally, the destruction and sabotage of infrastructure, industrial and commercial facilities owned by the Palestinians, along with the cutting off electricity, water, and essential services, including communication and internet services, isolating the Palestinian people entirely from the world. We refer to the special report issued by the Social and Economic Commission for Western Asia, as outlined in Resolution A/77/E/2022/66, which illustrates the catastrophic economic and social repercussions resulting from the Israeli occupation and its impact on the living conditions of the Palestinian people. 4. Imposing isolating measures by constructing the apartheid separation wall, depriving Palestinians of their right to move between Palestinian cities and forcing them to wait at crossing gates for long hours, sometimes extending to days, without permission to pass. Additionally, the occupying entity enforces a permit system for movement that hinders the entry of goods and medical supplies. Your esteemed court issued its legal opinion on July 9, 2004, stating the illegitimacy of that wall based on the reasons outlined in the decision. Five, seizing Palestinian lands, establishing and expanding settlements on them, and the ongoing detention of thousands of Palestinians, including children and women, in detention centers under harsh conditions, affecting their health and jeopardizing their safety without trials according to legal principles and without providing proper care, which could lead to deadly consequences. The occupation authorities also continue to deport Bedouins from the Palestinian population from their original areas to other regions, seizing their lands the Israeli occupying entity persists in violating the basic human rights of the Palestinian people, as well as the principle of international humanitarian law regarding the protection of the civilians during armed conflicts. Mr. President, members of the Court, based on the aforementioned, the occupying authorities are obliged to comply with the duty to respect the right of the Palestinian people to self-determination. They must immediately cease the violation of their international commitments and to respect the right of the Palestinian people to self-determination by ending all actions and measures that prevent and hinder the Palestinian people's right to self-determination. This includes the immediate termination of the occupation with all its associated actions and practices aimed at prolonging the duration of the occupation and continuing to deny the inherent rights under the rules of international law to the Palestinian people. Mr. President, members of the Court, the Republic of Iraq is deeply concerned about the humanitarian suffering inflicted on the Palestinians throughout the state of Palestine, particularly in the Gaza Strip, due to the barbaric acts committed by the occupying Israeli entity by airstrikes and rocket attacks targeting civilians. These acts constitute war crimes executed with a criminal intent and serious violations of the laws of war. The Israeli occupying entity must be held accountable. The Israeli occupying entity must be held accountable for its actions, subjecting it to international criminal liability for violating the principles and charters of human rights and the Geneva Conventions related to the human rights during armed conflicts. We avail ourselves on the occasion of our presence in this great legal edifice today in order to embody the justice we see in your esteemed court in a strong and resolute stance to support the Palestinian people in reclaiming their violated rights and lifting the injustice about them. And lifting the injustice upon them. We call upon your esteemed court to take all measures and decisions that safeguard the lives of the Palestinian men, women, children, and elders, allowing them to enjoy a dignified and secure life where all human rights are achieved. Mr. President, members of the Court, please accept our sincere thanks and appreciation to you and to your esteemed court. Thank you, Your Excellency.
I thank the delegation of Iraq for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.